Hello, everyone. Welcome to our webinar today. Today, we're going to discuss the roles and responsibility of the ACC. My name is Cliff Davis. I'm a shareholder with the law firm of Roberts, Markell, Weinberg, Butler, Haley, and Paul Gaines, and another attorney in the firm, and myself. We're going to talk to you today about the ACC, Architectural Control Committee issues, and hopefully answer some of your questions. So some of the things that we're going to talk about today will be what are architectural control guidelines, whether or not you should have an architectural control committee. I'll wait for the slide to catch up. There it is. The approval process and violations, responding to homeowners who may have a delinquent fine or assessment or a deed restriction violation, and they submit an application for an architectural control improvement. And then we're going to talk about the legislative updates a little bit. So I'm going to jump right into it, start talking about what are architectural control guidelines. So most of you know your association has a set of deed restrictions that are the rules of what you can and can't do with your property. Those deed restrictions typically have language in there about architectural control that may lay the framework for the look and requirements of the homes, talk about other things, where the house can be located, how large it has to be, setback lines, all those types of issues. But most deed restrictions don't address every architectural issue. And so they leave some holes there, or there may be some ambiguity. And the purpose of architectural control guidelines is to try to address those ambiguities through the adoption of guidelines. And one of the benefits of these guidelines is that they can be changed over time. Typically, this is something that the board or the architectural control committee can adopt. If you don't have them, the association should consider adopting guidelines, but keep in mind that you've got to be authorized to do so. So really what it takes, and really with any issue, whether it's architectural control committee or any other issue an association is facing, deed restriction violations, you always first have to look to your declaration or your deed restrictions to see what authority they have in there. We can go on to the next one. And like I said, you would look at your restrictions to see if you're authorized or if the Architectural Control Committee is authorized to adopt guidelines. And if so, those are documents that can be adopted by that body, approved by the board. And as things change and as people present issues that maybe aren't addressed in the declaration or your existing guidelines, you can change those guidelines to address those issues, which happens all the time. So that's kind of a living document, breathing document that is going to have to be changed over time as new considerations come up or new issues are raised that the board can address. Remember, when you're always trying to impose any kind of standard, you really need to be able to point to it in writing so that owners don't think you're just making it up as you go along. So the guidelines on the next slide talks about a little bit about what they might address: the colors of exterior paint. You might want to have a chart of approved paint colors, fence requirements, landscaping requirements, the location of other outbuildings and other structures, of where they can be located, how large they can be. And if it's not addressed in the declaration and you've got that authority to have those guidelines, then you can address these issues. So one thing to kind of keep in mind is that your guidelines should not contradict any of the existing deed restrictions. So if there is a contradiction, the declaration, the deed restrictions are going to control, and you can't adopt something that directly contradicts that. And that, the devil's in the details with these guidelines. Anytime you're adopting architectural control guidelines, anytime you're adopting any other type of rule, there's always going to be an argument that it's an attempt to amend the restrictions without going through the amendment process. So there's always going to be somewhat of a tension there. There's some authority in case law that says that an association can adopt standards outside of the declaration. So you're always going to have that tension, and you're always going to have those owners that want to argue, you can't do that, you're imposing an additional restriction on me. And again, it comes down really to the language of your deed restrictions, or if you're in Harris or Montgomery County, there's some authority in the property code that you can adopt architectural guidelines, even if it's not in your restrictions. So just keep that in mind, that the guidelines should be to try to flesh out ambiguities. Some cases maybe set some additional standards that are always going to be subject to challenge. So, this is really something that when you want to adopt guidelines, it's a good idea to run them by your counsel. Typically when people come to me and say, we want to adopt some guidelines, I'll tell them, well, kind of make a list of what it is, the issues you want addressed, and then we can put it in a form that not necessarily bulletproof, but in kind of a legal format. And we'll go over the declaration and look at it to see, well, your declaration says this, so you can't adopt a guideline that says this. So, consult your attorney and get that advice to see if what you're trying to do is something that an attorney thinks you can do, or you have the authority to do. So most deed restrictions require the approval of the board or an architectural control committee before owners can put new improvements on their property or make modifications to existing improvements. And again, it's really important that you read the language of your restrictions. There are some older restrictions that say that if you want to construct a building on the property, you have to get approval, and that's all it says. Well, we've had owners make the argument, and they're probably correct, that you can't try to get them, require them to get approval for a fence, because the restrictions only talk about approval for buildings. So you really need to look at your restrictions, look at the language. If you're a newer subdivision, and by newer, hopefully from maybe the 80s to 90s on, the deed restrictions don't speak to just buildings, they speak to any type of improvement. And especially newer restrictions, speak to anything you can do on a property typically will require the approval of the association.
And Cliff, looks like we got our
Paul.
first question here. This is from Dan Eisenhower. States, if deed restrictions are silent on the ACC guidelines, can they be authorized by the HOA bylaws?
What I would say to that is it's better to have it somewhere than nowhere. So if you can amend your bylaws, or if it's in your original bylaws, you can point to that. If not, you can discuss amending your bylaws with your attorney to add that authority there. But know that the bylaws are more the administrative rules of how the association as a corporation operates. And there's an argument if you try to add that authority in there, that's something that's outside the scope of bylaws. But if that's all you can do, I would at least put it in the bylaws, knowing again that that's something that could be subject to challenge. And we believe that with regard to amending bylaws, that no matter what your amendment language says in your bylaws, there's some authority in the Texas Business Organizations Code that the board can amend the bylaws without a vote of the owners. And that's something you really want to talk to your attorney about, because there's some exceptions and there's some possible risk in doing so. But I generally tell associations, it needs to be in writing somewhere, we think, the authority to adopt guidelines. And so when you're going through that ACC process, you want to try to make it as smooth as possible. You should always have an application, and the application should have the owner information on it, what they're trying to do, provide information on what they need to give the association to consider that application. For example, if somebody wants to paint their house, you might want to require that they submit a paint card with it, or paint chips, the little card from the store that shows the color, so that you can get an idea of what that is. And I've had more than one occasion where the color on the card, when they put it on a house, doesn't necessarily look the same. So you've really got to pay attention to what's submitted, and have some due diligence to see if you're going to approve something that you might later regret. Because once you approve it, it's difficult, if not impossible, to undo that once the owner takes an action in reliance on your approval. Your application should be out there for everybody through whatever means available. Now with the internet and the requirement that most associations have to have a website, it should be on your website. it should be in an email format, so your manager or the board can email it, or the ACC can email it. So make that stuff freely available to the owners to the extent possible. So the question is always, should you have a committee? Well, if you have more than 40 lots and you're not under developer control, you must have what the law now calls, and this is the recent law that just took effect on September 1st, you must have what's called an architectural review authority. And it can go by many names. The most common name we see in the deed restrictions is the Architectural Control Committee. It can be called Architectural Review Committee, Modifications Committee, whatever that is. The law considers that an architectural review authority. And the law, there's some changes now in who can make up that body. And that's something that Paul's going to address a little later on when he starts talking about some of the legislative changes that took place. So by establishing a committee, it kind of makes it more efficient. It takes a load off the board, hopefully, that you can find volunteers to be on this committee. It gives people an opportunity to become involved in the community without being a board member. A lot of people don't want to commit to that kind of time commitment. And hopefully your committee will be consistent in how they do things and how they treat applications and treat everybody the same. One of the biggest problems we have with architectural control, with deed restriction enforcement, is consistency, which can change as the board changes and opinions change on how that should be done. And that always presents a problem. I always tell boards that you are stuck with the sins of past boards if they have allowed something to happen that violated the deed restrictions, or maybe they've allowed purple houses when that's really not something most people wanted. You get stuck with those, and you have to deal with that when somebody comes along and says, I want this, and they can point to other houses where it's been approved in the past. So that's always a problem. And consistency is a difficult thing for boards, or can be a difficult thing for boards and architectural control committees to get to, but that's really where you want to try to get, is where you're being very consistent. So, what happens when you get an ACC application? Most restrictions give the ACC a 30-day window to either approve or deny the application. In most restrictions, if there is not a response within 30 days, it's deemed approved. We have seen some, and we know of some, where it's deemed denied. But typically the language is, if you don't respond within 30 days, the application is approved. Again, this is something you really need to look at your restrictions and understand what your time frame is. If you get an application, the goal should be to try to respond to it as quickly as possible and not just sit on it until the 29th day and respond. So, you want your committee to function efficiently, and part of that would be responding to these things in a timely manner. If you get an application and you realize quickly that it doesn't have enough information, my recommendation is that the response not be, hey, we got this, but we don't have enough, we need some other information, is to deny that application, because you don't want somebody to play gotcha on you and say, well, the deed restrictions say you have to approve or deny within 30 days. And if you don't do that, it's approved. And you didn't do that. You said it's insufficient. So my recommendation is you send a denial letter, but if it's insufficient information, but in that letter, you specify what is needed for the Architectural Control Committee to consider that application. I believe it's probably a good idea to send denial letters by certified mail to owners so that you can prove that you sent it. You don't necessarily need for them to sign for it, but I've had more than one instance where the association sends a denial letter and the owner just says, I never got it. I thought it was approved automatically, so I painted my house pink. So that's something to think about, is you just got to be able to show that you sent it. You don't necessarily have to show that they actually received the letter. And you've got to watch that automatic approval provision. That's a problem for a lot of associations. Again, don't wait till the last minute try to get to them quickly, especially try to review them within a day or two, just to determine if you've got enough information to even consider the application. And I think that's what we talk about here on the next slide is you don't want to be unreasonable. You know, if it's somebody is saying, I want to repaint my house the same color and it's white, and it's obviously something that's going to be approved, you know, those are the things where you can approve in a couple of days, hopefully, and not wait 29 days to tell them yes on something that really is kind of a no-brainer. So those are the things that I'm going to talk about today. I wanted to leave Paul 45 minutes to talk, so I got through mine quick. And when Paul's finished, we're going to answer some questions. We got a lot of pre-submitted questions, and we'll go through those and then try to answer questions as they're asked through the Q&A function. Go ahead, Paul.
Thanks, Cliff. And before we begin, we'll take care of a few of these questions that were submitted while Cliff was discussing the ACC requirements. The first one, what determines if guidelines need to be approved by HOA board or ACC? You need to take a look at your declaration. I will say that most of the time the guidelines will be approved by the ACC, but sometimes it takes both the board and the ACC's approval, depending on the specific provisions in your declaration.
Hey, Paul, let me make a comment on that too.
Sure.
I would advise, even if your declaration is clear that it's the ACC that has to adopt those guidelines, the board should also always approve them. You know, keep in mind that if somebody sues the association over an architectural control issue, you know, they're suing the association, and the board is the body that runs that association. So on any policy or guideline, you know, my recommendation is they always also sign off on it.
Yes, good point. You know, it's the more the merrier, and if you have more signatures on it, that just shows that both governing bodies would be approving that document. The next one, can the review body be the management company? We've had this question a lot, and the answer is yes, depending on what your declaration actually says. Because if it says the ACC members have to be members of the community, well, in that instance, it might not work. Let's see, next one. Can our committee require that specific contractors be used for work? That can also be a tricky one. It depends on how broad your guidelines can actually be. And if you're using specific contractors, you want to make sure that you're not limiting it to only 1, 2, or 3. And you want to make sure there's not some kind of relationship between that contractor and any of the board members either. So there has to be a reasonable basis for any contractors that are denied or used. And instead, I would suggest just an approval process for the contractors instead of just limiting it to maybe 2 or 3.
Hey, Paul, on that one too, my advice to associations is you don't want to get in the business of approving contractors. I just don't know why you would want to do that. You know, I think owners would push back against that, telling them you can't use that contractor because we don't like him for some reason. I mean, that to me, that's a relationship that should be left between the owner and who's doing the work. You know, there may be some instances where that might be a good thing, but for the most part, to me, all I can see with that is trouble for the association.
Yeah, you can definitely run into issues with that. And I've seen with some of my clients that unfortunately they have a lot of bad instances with specific contractors, and that's what gives rise to these approval requests. The next one, let's see, what if the Purple House issue never requested approval, but the previous ACC did nothing about it? Can my ACC do something to change it? It's all going to depend on the statute of limitations. You know, if they painted that thing more than 4 years ago and it's been sitting there purple, then the association might be barred, or the ACC might be barred from enforcing that Purple House. Okay, so let's continue on with the slides. I'll go ahead and discuss variances real quick. So on rare occasions, an application that might normally be denied may require a variance from the association. This is typically a variance from any other applications that might have been submitted, or setback issues. Somebody wants to construct a shed in a certain setback area that's not allowed by the restrictions. But variances are a very sensitive issue. They should only be granted if the restrictions, one, give the association specific authority to grant the variance, and then also they have to be reasonable in light of the circumstances, and they may be limited to situations where the hardship is due to the nature of the property. So really take a look at your declaration before you grant any variances, because sometimes those variances can be very limited into what authority the ACC actually has. And then sometimes the variance authority is not there at all. After approving or denying the application, the association should pay close attention to the property for which the application was submitted. This would prevent the unapproved or modified construction of any shed or any other improvement they want to put on their property. We have seen in the past that individuals will get a certain approval and then they'll start constructing, and their construction is way out of line with what was actually granted. During the process of construction, modifications to the submitted design may become necessary in the future. The owner, of course, should follow the ACC guidelines, which might also include resubmitting an ACC application for approval if there's some kind of deviation from the original approval that was given by the ACC. Under extreme circumstances, in that hypothetical I was giving where somebody gets an ACC approval, they go out and build something much larger or something that just does not comply with that approval, it may be necessary for legal counsel to become involved. This might involve a cease and desist letter, or in extreme situations, a temporary restraining order requesting that a court order them to stop any construction. And the temporary restraining order is very important, especially whenever it comes to individuals pouring cement or trying to lay a slab, because once that's there, it's very difficult to, of course, get that taken up, and courts might be hesitant to get an owner to go out there and break up a slab. The boards or ACC may run into a situation where the owner is delinquent on fines or assessments. The association should always look to its governing documents for clarification regarding the scenario, because there might be a provision in there that allows the board or the ACC to deny the application based on the delinquent fines or assessments. If there is no provision, then you likely cannot do that. And the board of the ACC should always consider the application based on the association's guidelines. So next we'll go into the new 87th legislative session updates relating to ACCs. There are a few very important ones. We've got a lot of pre-submitted questions regarding some of these new laws. So we'll go ahead and jump right into it with the biggest bill that affected POAs in this 87th legislative session. That's Senate Bill 1588. Section 3 of Senate Bill 1588 would add Section 202.022 to the Texas Property Code. This will prohibit associations from adopting or enforcing provisions in governing documents that would prohibit or restrict an owner from installing a swimming pool enclosure that would conform to applicable state or local safety requirements. Association may enforce provisions related to the appearance of the enclosure, including the regulation of colors. However, such regulation cannot prohibit a black swimming pool enclosure that consists of transparent mesh set in metal frames. Since this is Chapter 202 of the Texas Property Code, this will apply to both single family and condominiums. And this is effective this month, September 1st, 2021. So this law is currently effective. Section 11, very important one regarding ACC members and board members. This particular law will prohibit people from serving on the ACC if the person is one, a current board member, a current board member's spouse, or a person residing in a current board member's household. Owners are permitted to appeal a decision by the ACC to the board under this specific law. Notice of denial, including the basis for the denial and the reasonable detail and changes, if any, for a conditional approval, must be provided to the owner and board, and they must hold the hearing within 30 days after the date the board receives the owner's request. So this is getting similar to the old 209 hearings under Chapter 209 of the Texas Property Code. This is effective September 1st and will apply to single-family communities with more than 40 lots. And very importantly, it will not apply during the development period. To continue, the notice must be sent to owners providing the date, time, and place of the hearing not later than 10 days before the date of the hearing. You only have to have one hearing. During the hearing, the board and the owner provide an opportunity to discuss, verify facts, resolve the denial by the ACC, hopefully, and then both the board and the owner are permitted to postpone for a period of not more than 10 days. And just like 209 hearings, the audio recording is permitted by both parties. And then quickly, we'll touch on the new process for 209 hearings that came about from Senate Bill 1588. So the new 209 hearing process is effective September 1st, 2021. So if there is any request after September 1st, 2021, regarding a 209 hearing, the new law has to be followed and these new provisions have to be adhered to. So this will amend section 209.007 of the Texas Property Code. States that not later than 10 days prior to the hearing, the association must now deliver a packet to the owner containing any evidence it will introduce at the hearing, photos, documents, communications, anything related to that specific violation or what's making up that 209 hearing. If the evidence is not provided, then the owner will get a 15-day postponement. And then during the hearing, the board is allowed to present its case first, and then the owner is entitled to present his or her case. So before, when 209 hearings were friendly meetings to try to resolve any specific issue in the community relating to a violation, they have really become more of a mini trial under Senate Bill 1588. And again, this is effective September 1st, 2021, and will only apply to single family associations. House Bill 3571 relating to security measures. This is also included within Senate Bill 1588. This will prevent associations from restricting the installation of security measures such as cameras, motion detectors, and perimeter fencing. That is not an all-inclusive list right there. So really it just comes down to any kind of security measure that there is. Can regulate the type of fencing or installation on other property. And because of the impact of this specific bill and now law that's effective September 1st, 2021, we do recommend that associations adopt security measure policies. Now, of course, you want to make sure that you have the authority to adopt these policies, but unfortunately, with this new law, there's a lot of gray areas that came about with this, and we just believe that many associations would benefit from adopting this policy, clarifying what's permitted, what's not permitted, and then also addressing perimeter fencing, and then also any regulations of the type of that fencing as well. Okay, so that concludes our presentation today. Now we do have some time for questions. It looks like we have a good amount of questions that were submitted. Cliff, you want to start on the pre-submitted or the questions that were submitted just now?
I'll go with a couple of these pre-submitted questions.
Perfect.
We'll start with those. How long must a violation exist before it is considered as being grandfathered in? Can we set what that period is, and what's the default time period if we don't? So Paul mentioned it before, there's a statute of limitations. It's a 4-year statute of limitations, which means you have to file a lawsuit within 4 years of the date you knew or should have known of a violation. So keep that in mind, that you can't just sit on these violations when you see them. You need to pursue them, and if necessary, you need to file a lawsuit. How long must the well, that's the same question. Who's responsible for retaining records on approved exceptions from the architectural standards? So the property code states that the association has to maintain account records of an owner for 5 years. I would think that includes not only financial records, but any type of record. So keep that in mind, that you should maintain those records for 5 years. You know, hopefully if there's going to be an issue, it's within that 5 years time period. We come across that on occasion where somebody says they got approval from, 12 years ago, and I've taken the position in some of those cases is that, well, you need to show that you have that approval. If it's within 4 years, obviously they need to show that they have that approval if the association doesn't have it. But I guess the point is, the association should be keeping those records for at least 5 years. And if not, you can ask the owner if they have it. If they don't, you probably need to talk to your attorney about what your options are on how to pursue a violation, which nobody seems to have a record of an approval. Do exceptions from architectural standards get carried forward in perpetuity or just for that specific owner? So what we're talking about here is a variance. And I think, as Paul mentioned, you shouldn't really be granting variances unless your documents give you variance authority. And a variance can be a temporary variance that's only good while that owner owns the property. In some cases, it can be a permanent variance. If it's going to be something that's going to affect the next owners, you might want to think about filing that variance with the county records so that it's never gone. It'll be there till the end of time, and that the owner buying the property knows that a variance has been granted.
Yeah, and to add on to that, if you are concerned with a specific variance, it's getting complicated, get with your legal counsel to help draft the variance, because oftentimes, as Cliff said, you might draft a variance and think it only applies to the specific owner of that property, but yet the way it's written, it would apply to any owners of that property because it would run with the land. Many times we see these variance requests whenever there's maybe a conveyance of the property, and the new owners say, hey, there's this issue with maybe something built in the setback, what have you. Typically, those instances, you will get with your attorney, they'll draft it, and that kind of variance would be filed. But if it's something that's only related to a specific owner, just make sure that the language is very, very clear that upon conveyance, that variance will terminate.
So we've got one, and we've got a couple here that are related to who can be on the ACC. And this question is, if currently an ACC member is also a board member, when will they have to relinquish the ACC position? We believe the intent of the law is that as September 1st, board members cannot serve on the ACC. Now, there's an issue out there if a board member is serving, if an ACC member is serving a term that extends beyond September 1st, can they finish out their term? I mean, arguably, yes, but in our experiences, there's very few associations that are strictly following a term for an ACC member. So, if your association has 1-year terms for ACC members, and that's somewhere in your documents, and you can actually show that, you appoint them, they serve for a year. At the end of that year, they're either reappointed or somebody new is appointed. You may arguably be able to say that you're going to wait until the term expires and then the board member will fall off the ACC. But again, we believe the intent of the law really is that board members are no longer on the ACCs as of September 1st. What involvement can the board be involved in an ACC committee? I don't think it's a bad idea for there to be a specific board member that's a liaison, that maybe sees all the emails or goes to the meeting where the ACC considers and approves and denies applications, so they can keep an eye on it and report back to the board. Just that person can't have any part of voting or approving or denying. But as most architectural control committees can be appointed by the board and removed by the board, the members, it's a good idea for the board to take action to kind of monitor what the ACC is doing. There are some instances where the ACC is truly a separate body and they're elected by the members, and that's all in the declaration. But for the most part, it's something that the board needs to really watch and oversee. And if you get a rogue committee, you simply remove those people and appoint a new architectural control committee. And again, that depends on your documents.
I'd like
Oh,
to
you want to take a couple of
yeah, I'm going to add on real quick
Okay.
To that issue. And just to make it clear, the new law does not make the ACC autonomous. So most of the time, the declarations will provide, the board's the one who appoints the committees, also appoints the ACC members. Now, as Cliff stated, some declarations are different. You'll have autonomous ACCs, they're elected by the members. That's a different scenario. But if the board is the one under the declaration, under your declaration, that appoints the ACC members, they can still have oversight of that committee. You just have to have the distinction between board members and ACC members.
Hey, Paul, let me do one more of the pre-submitted, and then why don't you start on the questions asked during the seminar.
That sounds good.
This question is, what options does a 12-home single-family association have if only current board members or the spouse of a current board member wants to be on the ACC committee? The good news for you is that these requirements that the board can't serve on the ACC only apply to lots that are over, to associations that are over 40 lots. So if you're under 40 lots, or if your association is still under developer control, board members can serve on the ACC.
All right, so let's go ahead and jump in to the, looks like we got about 50 questions here. So we're gonna do our best to get through all of them within the time that we have. To start, what is the difference between a policy and a guideline? So guidelines are typically related to ACC guidelines that are adopted by the ACC. And as Cliff mentioned, it's always good to have the board sign off on those as well. Policies are typically adopted by the board, and that would relate to any and all aspects that they would have control under the declaration. But always make sure that you have that nice broad rulemaking and policy making authority before you go off and adopt any policies. And then also the guideline issue, make sure you have the right under the documents to adopt those guidelines. Subassociation that's gated of a master association. The subassociation has its own ACC rules. Does the sub have to adhere to the master association? So typically, subassociations are subject to the master declaration. Whether or not they're going to be subject to any additional ACC documents or guidelines really depends on the language of the specific declaration. I will say that a lot of times we run into the situation where the master will have a subset of ACC rules, and then the subassociation will have maybe a more stringent set of guidelines. So in that case, of course, you would still rely on the subassociation's ACC rules and compliance therewith. If a violation is ongoing, for example, a homeowner doesn't mow a yard or otherwise maintain the property, is that an ongoing violation that a new board can enforce going forward, even if the previous board did not? So in these situations, there is a difference between something like somebody paints their house, that's been there for statute of limitations for 4 years, and you cannot enforce that because, again, the 4 years have passed. If it's an ongoing violation, so they mow their lawn, the grass grows very high, you send them a letter, they go out there and mow the lawn, and 2 months later, that would be considered an ongoing violation. You can make the argument that yes, every single time that the violation started again, you could go out there and enforce, and the statute of limitations would start after the last violation. Next, let's see. In terms of consistency, what can we do when a homeowner applies to make an improvement that is not allowed per the deed restrictions, and they find the same improvement done on another house that was never approved by the ACC, but was never cited as a violation? So if it was never approved by the ACC, I guess it depends on the circumstances, because we've had this argument a lot. Somebody submits an application, says, hey, I want to paint my house pink. And the ACC says, no, that's not in line with our deed restrictions. And then they point to a pink house down the street. Unfortunately, you can run into some defenses in that regard. We've seen a lot of lawsuits that arise because of that. One person having something, then they disapprove another similar application. And then you get in the argument of, hey, is that arbitrary, capricious, and discriminatory? So that would be a case-by-case basis. And I would say if you do have that situation, definitely get with your legal counsel to give you an opinion on the pitfalls and then the upsides of your case if you were to go ahead and enforce that.
So Paul, let me add on to that too. So, really what the owner is saying is that, well, you've waived the right to enforce that restriction because it happened here on this house. And like Paul said, you need to talk to your attorney, but that comes down to, one similar violation that was allowed to happen at some point doesn't necessarily mean you can't enforce the restriction against the new person that wants to do the same thing. I mean, if it happened 2 months ago and you didn't do anything about it, you might have a problem. But if it's something that happened 10 years ago, I think you can still pursue that. And the argument is, like I said, is, well, yeah, that happened once. It happened once. That's the only other instance in the neighborhood. That's not enough for us to have waived the violation. That was a different board. This board has consistently enforced this restriction. Here's 4 other denials in the past 2 years where we denied exactly that same thing to show your record of consistency on that. And it's, again, it's not necessarily 100%, but it is a strong argument if the association for the last few years has said no, no, no to everybody that's asked.
Yeah, and again, case-by-case basis, we definitely don't want to say that you cannot enforce it, because a lot of declarations will actually state, hey, if the association doesn't do one thing, it doesn't waive their rights to enforce in the future. So definitely take a look at the provisions for their declaration as well. To what extent can policies, standards, etc., be used to supplement or eliminate limitations set forth in our governing documents? They cannot be used to eliminate anything in your declaration. So they cannot conflict with your declaration. They cannot conflict with your bylaws. However, they can be used to supplement, depending on exactly what's put in there. But again, you do not want those to conflict, or you don't want to try to, of course, amend the declaration with a policy, because that will take a membership vote. Can the committee delegate some approval decisions to a hired person? For example, offenses clearly within the restrictions and guidelines. I suppose this is related to the third party being hired to act as the ACC. We have seen these requests, and it really depends on your governing documents. So some associations might be able to do it. Other associations might have a provision stating that ACC members have to be community members.
Hey, Paul, I've got a couple more pre-submitted, and I'll get to those real quick here.
Sure.
This question is, what steps are needed to update the ACC? What's the most effective and time-saving way to do this? I guess what the question seems to be asking is, how do you update your guidelines? And again, unless it requires an owner vote in the declaration, which is extremely rare, that's something that the board and or the ACC can do to update those. So again, those types of policies and rules typically are a board function, or in this case, perhaps an ACC function. And if you do amend those, keep in mind that guidelines and any other rule on any other subject you adopt, you have to file it with the county in order for it to be enforceable. It has to be adopted in the open session of a properly noticed board meeting. Got another question here. Will our current D&O insurance cover the ACC members since none of the committee members are on the board? The answer to that is typically yes, but that is something you want to confirm with your insurance broker, your insurance carrier. In most instances, committee members will be covered. If they're properly appointed, they will be covered by your insurance. There's a question here that was submitted, and I think it's in response to something I said. It says, I missed your answer. Did you say for an ACC application denial letter, proof of receipt is not required? So what I was talking about is the instance where an owner says, well, I never got the denial, so I thought it was approved. If you send it by certified mail, you can prove that the letter was sent. And of course, it should be sent by regular mail also. So that's evidence that you actually did send the denial letter. When you send the letter by certified mail, you can't make an owner sign for those. So you don't have to typically show proof that they received it. You just have to be able to prove we sent it. And then it becomes a fact question of if they received it or not. But if you've got a certified mailing that was returned to you, you obviously didn't mail it. So it takes away their argument that it was never mailed. I'll read a couple more, Paul. If an ACC application is denied and the homeowner asks for a variance, is the board obligated to follow the new legislative hearing requirements, or can they just address it in executive session? So it depends on what the owner asks for. If they are appealing a denial, you have to go through the hearing process. If they're asking for a variance, you don't necessarily have to go through that process. And again, the thing to keep in mind with variances is you need to make sure that your documents give you variance authority in the declaration. Now, I think probably for your guidelines, you can give yourself the authority to grant a variance, but if they're asking for a variance from a requirement of the declaration, there needs to be variance authority in that declaration. Can I be personally sued as an ACC member? Yes, the answer is yes. So if you are thinking about serving on the ACC, you should have your board confirm that you are covered by the association's insurance. I'll do another one, Paul, then I'll let you take a few. Regarding the 30-day rule, we have established that the drop dead date is not applicable if the ACC has responded and asked questions regarding the homeowner request within 30 days. I don't think we've established that. My point is that if you need additional information, the best, most conservative advice is to issue a denial letter. And in that denial letter, ask for what documentation you need or ask for what questions you need answered. We have seen in a few cases where an owner plays gotcha because they got a letter asking for questions or saying there's insufficient information. And after 30 days, they say, ha, you didn't deny it, it's approved. So keep that in mind.
All right,
Paul, you want to take over?
let's continue on. So we got a question here. Hi, our declaration contains a definition of the ACC. The Architectural Control Committee shall be comprised of no less than 3 and no more than 5 members, all of whom shall be appointed by the Board of Directors. Majority of the committee may designate in writing a representative to act for it. Currently, we have 2 board members acting as liaisons and 1 non-board member acting as a chairman. The chairman receives all submissions with board involvement when necessary, as this set up now in violation of the new property code. So as long as the board members are not ACC members, you should be on good footing. It looks like the non-board member is currently acting as a chairman, so that would just be the chairman of the ACC. So make sure, in accordance with the statute, that you're just separating those positions of board members and ACC members. But if the board has oversight, such as it does here, being able to appoint the ACC committee, they can have those board member liaisons for the ACC. Let's see. Should the communication be with the owner or the contractor from the management company if issues arise? Let me go ahead and read that again. Should the communication be, or this might be a 2-part, maybe not. Should the communication be with the owner or the contractor from the management company if issues arise? So wrong color, trash, debris, that's going to be a communication with the owner, because the owner is the one, of course, who owns the lot at issue. Will I have access to this recording, as the information is very good, but there is much, and the ability to go back and review would be very helpful. Please advise. Yes, we do post these recordings and these presentations on our RMWBH YouTube channel. If anybody has any questions on where to find that, we can definitely let you know, and we can get our marketing team to send you a link. If sending a denial of an application, can it be emailed with an email read response flag in the system? Would that suffice legally? I would recommend sending it certified mail, but if the owner gives approval in writing that email is sufficient, then I think that you would be all right. Cliff, you got any comments on that one?
Yeah, I think if you've got something in writing where the owner approves communication by email, in that instance, you should be okay. But otherwise, I would, even if you send emails, I'd still feel more comfortable with sending a letter, unless the owner has affirmatively said that they only want communication by email on that issue.
So if ACC board member is the contractor on an application, do they still get to vote? No, and I would not recommend that situation. If there's an ACC application that comes in and an ACC member has an interest in that application, that is not going to look good. I would not recommend that situation.
Paul, you want me to take a couple?
Sure.
So this is, can an ACC hold an application due to ownership not matching the requester, house sold, and new owner wants to request to paint, but HOA records still show the previous owner? Can they hold the application? I think that's one where I would send a denial and say, our records don't show you as the owner, please provide a copy of the deed. And then we can consider the application. So they should be able to get a copy of the deed fairly quickly, and your attorney should also be able to get a copy of the deed fairly quickly. If a neighbor asks to know what the neighboring property is installing, can you share any information? What if they want to see plans of the neighboring property? So whoever wants to see something, they need to make a records request in accordance with the property code. And the property code says that records requests have to be sent by certified mail. Once you get that records request, you need to try to determine exactly what they're asking for and get with your attorney to see if they're entitled to see what they're asking for. Definitely, I would not give up anything that shows the interior layout of the house. Maybe a copy of the application and a copy of the approval letter. But generally, it's not a neighbor's business. That business is between the applicant and the association. But they can make a records request, and you just have to determine what they're asking for and if they can see what they're asking for. What can we do when a flipper comes in and makes unapproved improvements and ignores any citations due to knowing the property can be sold? before any HOA action is taken beyond the initial citation. So, that happens. The flippers come in, they do some work quickly. There's options out there though. If you think you're in that situation, we have something we file that we call a notice of alleged violation that we file in the county records that says, there's a violation, describes the violation, names the owner of the property. When the flipper tries to sell that property, if that buyer wants to get title insurance or a loan, they're likely going to find that document, and it is going to hold up the sale until that document is cleared. So keep in mind though, that when you file those documents, you're clouding title on a property. So you got to be careful to make sure that you are really in a good position to say that there is a violation. And there's always the option of filing a lawsuit for a temporary restraining order, which is something that the day of or the day after the lawsuit's filed, you go to court and you get a ruling from the judge that orders them to stop doing what they're doing until it's approved or until the restrictions are complied with. Those lawsuits are out there. That type of lawsuit, they're very expensive because it requires that your attorney go to court that day. They may sit down there all day waiting to get in front of a judge. Temporary restraining order is good more or less for 2 weeks. It can be extended for an additional 2 weeks. However, soon after that, if there's not an agreement, you have to have a temporary injunction hearing. So the temporary restraining order says stop what you're doing. The temporary injunction hearing, which is the next step, says you have to stop until there's a final trial on this matter. The temporary injunction hearing is a mini trial, so that can be very expensive. But again, when you file that lawsuit, it should stop the action or create a cloud on the title to where it'll be difficult for that person to sell that house.
Yeah, and Cliff, to touch on the deed restriction enforcement process, we have a few other questions concerning unapproved improvements that are built. What are the options? And just to let everybody know, for that process, it's going to be your standard deed restriction violation process. You send out the requisite 209 notice, you send it over to your attorney to enforce, and then if a lawsuit is necessary, you will go forth with injunctions. And then of course, you'll be seeking attorney's fees, costs, etc. There are also civil penalties that can be collected as well. So for this one question, what if a structure is put up without approval and breaks the rule of setback? What are the options? Definitely get with your attorney. Once you send that 209 letter, it expires. They fail to cure, it can be turned over to the attorney for enforcement. I believe there was one more. What if ACC recourses, what are the ACC recourses if a homeowner built something that was never approved or even a request for approval? Again, it's going to be the deed restriction enforcement process.
And Paul, just to add on to that, so construction can be a big problem if somebody starts building something without approval. And so you've got a couple options there. One is to send a cease and desist letter, and I think there's a question about that. And basically saying, hey, what you're doing is not approved. You need to stop immediately. That can come from the association. It can come from the management company, and in some cases, it can come from the attorney. Sometimes if the cease and desist letter comes from the attorney, it carries a little more weight with the owner, because when we write a cease and desist letter, it says, if you don't stop, we're going to sue you. But keep in mind, and I have some boards that are confused that think that is some kind of an order, and it's really not. It's a party taking a position that there is a violation going on, and in this case, the party being the association. And they're telling the person, you need to stop now. But the only penalty if they keep going is you've got to go to another remedy. And in that case, it would be a temporary restraining order lawsuit. And those don't get filed often. And typically when they do, it's because of unapproved construction that appears to violate the deed restrictions. So you've got that cease and desist is another option out there. Obviously you can't send that if they've already constructed whatever it is they're going to construct. And in that case, like Paul said, you just have to go through your normal process. However, if somebody builds a storage building and they didn't get approval, your violation letter shouldn't say you didn't get approval for that letter. It should say you've got an unapproved storage building and it is not going to be approved if you submit for it. So, you don't send a letter saying submit an application and then they submit one and then you deny it and you knew you were going to deny it all along. If you're not sure, you can send a violation letter for that. But if it's something that will not be approved, even if submitted, you should tell them in that initial letter that's not going to be approved, even if you submit for it. So just keep that in mind. Courts don't like to see associations making people jump through hoops that when the association knows they're going to deny that, even if they do apply for it.
Okay, so next we have what amount of contact is allowed between the board and the ACC committee. The board and the ACC committee can contact each other all day. What the new law does is separates the positions. So you have board members, you have ACC members. So board members should not be acting as ACC members. They should not be on the ACC making those decisions for the ACC. But if your documents state that the board is the one who appoints the ACC members, then yes, the board should have some oversight of the ACC committee. That would include communication.
Hey, Paul, there's one here I think we've got to get to, because you and I talked about this beforehand, is what are the consequences if you can't get any volunteers for the ACC? Can the board continue to review applications until an ACC is formed? So, this is an issue for a lot of associations who can barely get people to serve on the board and now have this requirement for the ACC. We think what you have to do is you have to be able to show that you've done everything possible to get volunteers, which will include, putting stuff on your website, sending an email blast, sending a letter to every owner stating we need volunteers to be on the ACC, and be able to document that. And if you simply can't get anyone, the restrictions still require that an application be approved or denied. So somebody's going to have to do it. And in this instance, that somebody will have to be the board. And when somebody challenges that, you've got to be able to show that you bent over backwards to do what you can to get volunteers. And that may not be enough, but that is really the only other option out there. And, we had, I think, over 400 people sign up for this. If all of you would call your state representative and let them know of the issues that they have created with this law prohibiting board members from serving on the ACC, we may get something changed in the next session. We have many associations that are up against this problem, and they just simply can't find the volunteers.
Yeah, to add on to that, communication is key. Reach out to your representatives. I think that with the passing of Senate Bill 1588, not a lot of thought was put into it. And now we're going to see the pragmatic effect on associations. And I think that, with stories of exactly how this is affecting associations and board members and ACC committee members, that we might get some changes on the next legislative session. And to address also what Cliff was discussing, if you just cannot find the volunteers, and this happens all the time, it's hard to find people to take time out of their day and be a volunteer for the ACC committee. If that's the case, make sure you're making that good faith effort, documenting everything, and continuously searching for ACC members. But Cliff makes a good point. The show must go on, especially if you have that 30-day deemed approval provision in your declaration. So again, if you have any questions, make sure to reach out to your legal counsel regarding this. But if you just can't find those ACC volunteers, keep on trying.
Paul, there's a question here. How many members have to be on the ACC committee? The documents may say a number, but at least one is good enough. I mean, you should try to comply with your documents, but if you're having trouble finding volunteers and you only got one, I don't, in that case, I would say, well, having a one-member ACC committee that may violate the provisions of your document is better than the board serving as the ACC committee.
Agreed.
So we've kind of run out of time here, Paul. We've got, this issue has generated a lot of questions. We're sorry we can't get to everybody. We hope that we got to as many as possible. And your other questions you can submit to your attorney. We're always out there if anybody's looking for help.
Yep. Thank you very much for attending. And like Cliff said, if there's any questions, please let us know.